Hi guys. Oh, that was my husband in the background. He exists. Yeah, no, I'm just making him up. Okay, so we are up to week 8. We are starting on page 27 of our work booklets and we're looking at responses to problems in family relationships. You'll see we have 2 red boxes at the top of your page. So the 2 at the top here outline the legal processes involved in dealing with problems in family relationships. That is one of your red boxes. And the second red box that you are filling in on page 27 is evaluate the effectiveness of the law in achieving justice for parties involved in relationship breakdowns. Okay, other red boxes we'll get to later. So we're going to be looking at divorce and the legal consequences of separation, in particular when it comes to children and property. That's all going to be on this video. On the next video, which is also for this week, we're going to look at dealing with domestic violence. Next week, we will look at the role of the courts and dispute resolution methods and non-government organisations and the media. Okay, so once again, those 2 red boxes at the top, outline and evaluate, the long skinny ones, they're going in your red boxes in your work booklet. Problems in family relationships that we are going to be dealing with at the start is, well, this week, divorce and separation and domestic violence. Divorce. Okay, so this is from the Matrimonial Causes Act from 1959. This is not the law today, but we're just going to have a look at what it once was. Okay, so once upon a time, the Matrimonial Causes Act gave 14 grounds for divorce, things like adultery, insanity, alcoholism, etc. You essentially had to prove that one party, whether that was the wife or husband, was at fault, meaning it was their fault that the marriage broke down due to, for example, adultery. Adultery is cheating on your significant other, for those of you who don't know the word. This actually caused a lot of problems and lots of aggressive behaviour, lies, etc., because someone had to cop the blame. Or, if you look at that charming gentleman above my head, that guy, some wives had lots of grounds for divorce to choose from. I mean, married for that. No, crossing that out, that is no longer the law. Today, under Section 48 of the Family Law Act, the only grounds for divorce now is an irretrievable breakdown of the marriage. You don't have to prove that your partner was doing the wrong thing. You don't have to say this is the reason why. There's just, for whatever reasons, been an irretrievable breakdown of the marriage. That is, the marriage cannot be repaired. Even though the requirement of proving fault is gone, there are still some specific requirements for getting a divorce. The parties, husband and wife is used as a terminology in these videos, on these PowerPoints, because up until fairly recently, marriage really was only between a man and a woman in this country. So please, every time I talk about the husband and wife, it could be the husband and the husband, the wife and the wife. Yeah, I'll try. Hang on. The parties, the married people, yeah, that'll work. They have to live separately and apart for 1 year. So 12 months, live separate lives. You cannot get a divorce unless you meet this requirement. If the couple has been married for less than 2 years, they must attend family counselling before they can divorce. And if the couple have children, no application for divorce will be approved until all the issues involving the children have been resolved. And then you have to just fill in the paperwork. Last time I remember somebody telling me that they did an online divorce. I think it was somewhere between $300 and $600, like for a legal cost. That's not too bad. Better than being married to someone you don't want to be married to anymore. Congratulations on your divorce. That's it. All you have to do to get divorced is to live separate lives for 12 months. If you've been married less than 2 years, get counselling. Make sure all issues are sorted out for kids, and then just do the paperwork. Divorce, easy peasy. Don't get married unless you. No, don't get married if you don't want to get a divorce. Still, whatever. All right, so the legal consequences of separation that we need to examine, and they are the most important, are children and property. These are also the same issues that have to be dealt with when de facto couples separate. If you remember, de facto couples are covered under family law pretty much the same way that married couples are, and they go through the family court. Okay, so these issues are heard in both divorce and de facto separation cases by the family court, as I just said, or the Federal Circuit Court. When it comes to children, there were changes made in 2006 which focused on making sure that these issues are worked out between the couple as much as possible before going to court. Remember, court is costly, can take a lot of time, and you don't necessarily want to be dragging these kinds of decisions out when it comes to kids. The other main focus is now that idea of shared parental responsibility that we looked at recently. Remember, under Part 7 of family law, any disputes concerning children must be decided according to what is in the best interests of the child or children. The court's primary considerations in working out what is in the best interests of the child are that the child has a right to maintain a meaningful relationship with both parents. Meaningful is more than just, a card at Christmas time. Meaningful is having, actual contact, conversations, and an actual relationship. The need to protect the child from harm. For example, if one of the parents is a bit dicey, you want to keep the kids away from that. These were swapped around so that protecting the child is the main priority through the Family Law Legislation, Family Violence and Other Measures Act in 2011. So we need to protect the child from harm foremost. Then we look at them having a meaningful relationship, as long as that relationship is not one in which the child is going to be put into a harmful situation. Deciding on what to do with the children. Step 1, try to work it out together without mediation. Step 2, if you can't work it out together, you have to go to a family dispute resolution to work out a parenting plan together with a mediator. Step 3, if you can't work it out at family dispute resolution, then you can ask a family court judge to decide on a parenting order. Remember, you're always best off doing the dispute resolution because then both parties can have a say in what happens, whereas if the judge is asked to decide, then the judge decides. You don't get to go, oh, but. A parenting plan is a voluntary agreement and most parents are compliant. That means that they do follow the plan. Who the child lives with. You need to work out where and with whom the children will live. Who the child spends time with and communicates with. Work out the timing or duration, length of time and nature, type of contact by the non-residential parent. The residential parent is the parent with whom the child lives. Non-residential, obviously, the parent the child does not live with. Together, these two elements make up a parenting plan. So who the kid lives with and how time is split so that there is that opportunity to have the meaningful relationship with both parents. A plan for specific issues such as education, medical issues, holidaying, sports and activities, etc. of the children can also be made. Most parenting agreements or parenting plans do definitely look at things like holidays. So for example, parent X has the child for Christmas this year, parent Y has the child for Christmas the following year, and they keep swapping back and forth. Mother's Day might be, if it's a male-female couple, Mother's Day with mum, Father's Day with dad, or if it's two mums, split it same as Christmas, 1 year on, 1 year off, or it might even be, Christmas mornings with parent blah blah and Christmas nights with parent blah blah blah, and then switch for the next year. Okay, many of you who have come from divorced families or who have seen divorced families are probably pretty, oh my God, what is that word? Oh, you know all about it. You're pretty used to these ideas. If parents cannot reach an agreement, then the court will make a parenting order which has the same parts as a parenting plan. Remember, this is red because it is better if the parents can work together and come up with an agreement that actually works for them as a family, rather than having a third party going, no, this is it. What are the usual parenting arrangements? Well, a lot of fathers' rights groups have argued for a long time that there's an unspoken 80-20 rule, where the kids only see their dad about 20% of the time. This is a reality in only about 28% of separated families. Changes in 2006 focused on equaling out the time spent with both parents. 50-50 time is a bit crazy given the realities of things like school, sleep and maths, like 7 nights divided by 2 does not equal a whole number. But shared care arrangements, anywhere between 35 to 65% of the time with each parent, make up about 14% of agreements. And it's not the courts doing this, all of this. It's not the courts doing this, all of this, really. Okay, syntax error me. The statistics is the same when it comes to shared care, whether it's arranged between the parents or decided by the court. This is always a controversial area, though, when you talk about the amount of time with each parent. For example, when it comes to the perception that the court is biased against fathers, please note, I've talked about your markers before. This is where I actually have put it in print. This is a very touchy issue. You cannot come down 100% on either side of this because you don't know whether your marker is a single mum who feels her kid's dad is horrible, a single dad who feels his child's mum is horrible, a man who had a mate go through a horrible custody battle, a woman who had a mate go through a horrible custody battle, a man who sides with men automatically, a woman who sides with women automatically, an adult whose parents divorced and it was a terrible time for them, etc., etc. So just talk about statistics, talk about the benefits of the child to have a relationship with both, talk about the benefits of the parents being able to reach an agreement rather than a judge making the decision for them, but don't get personal because you don't know who's marking your paper and what their personal experiences have been. Okay, the problem is that people are fairly or completely unaware that their own opinions can't help but make some difference in their evaluation of your view. If someone thought their own opinion was wrong, they wouldn't have that opinion. So obviously, if you make an intelligent point that goes against how they feel, it's way more difficult for them to acknowledge that you're right and they're wrong, because then they have to go home being wrong. Much more importantly, remember your markers are human and we should recognise and value their experiences in their personal lives. Saying that men are bad or women are hysterical is always morally wrong. What if your worker's an amazing mum who has been through hell and the courts didn't recognise that? What if your marker is an amazing dad who's been through hell and the courts didn't recognise that? Just quietly stick to the facts. Okay. All right. What happens with the kids is controversial, particularly when we look at through the eyes of domestic violence. We will look more specifically at domestic violence next video, but it still is something that has to sometimes be taken into consideration when decisions are made about with whom the child is going to live and how they're going to share time between parents. Okay, so it's only really been since 1995 that domestic violence has had to be taken into account when a judge decides on care arrangements. It's only since 1995. Domestic violence has obviously been going on longer than that, which is why it's red, because it's only been recognised fairly recently. Green is good that the courts are recognising that this is an issue that needs to be taken into consideration. The 2006 changes to put the child's right to have a meaningful relationship with both parents as a main priority has caused some issues when there are domestic violence aspects at play. The Family Violence Act of 2011 made sure that the safety of the child became the most important thing for the judge to consider. Remember, it was meaningful relationship, then keep the child free from harm, but then they switched it in 2011 to make sure that the child's safety was considered and then look at them having that meaningful relationship. In the case of Yusal and Mardine, 2014, Mardine was the wife, Yusal was the person who wasn't the wife, Mardine was given the right to take their young children to live overseas because her ex-partner was psychotic. Normally, families usually don't allow one parent to legally take their children to another country, but in this case, it was extreme. Even the judge declared the husband's behaviour in this case as a form of terrorism. So this is a case where the child's safety was most definitely put in front of that idea of having a meaningful relationship. Okay, I haven't looked at where we're up to in pages for a while. Let me just do a flick. Oh my goodness. All right, we are on page 30, but you don't have to do any writing. All right. There is a problem about domestic violence allegations in family court cases. Neither side's very happy with how these allegations are dealt with. Here we have an example. Innocent mum and kids have actually been abused but dads want to win, so he convinces a social worker and a judge that he's no risk to them. Mum's horrified by the injustice, and domestic violence groups call for a complete change to protect mums. Rosie Batty calls for a Royal Commission into Family Court's treatment of domestic violence survivors. Don't know if I've attached anything, but I'll just talk about it briefly in case I haven't. If you're not familiar with Rosie Batty had a son. There was a violent relationship with her husband. The marriage ended, and the husband had some issues. I guess some issues around anger is probably the best way to describe it. And he proceeded one afternoon to go to his son's cricket practice and beat his child to death with a cricket bat in the cricket nets in front of other parents and children, and his son died. Rosie Batty talks out a lot about domestic violence in Australia and was actually named Australian of the Year at one point. So there is and was a real need for domestic violence to be considered when it comes to protecting children. Okay. Here's another example. Mum and kids have not actually been abused, but mum wants to win, so she lies about it and alienates the kids from the dad. Judge believes mum, dad's horrified by the injustice, and fathers groups call for complete change to protect dads. In both these situations, it's so hard. It's very much a he said, she said, which is why, ladies and gentlemen, if you are ever a victim of domestic violence, report it, have it on record. It could save your life or someone you love. Another area in which this is controversial is the delays and underfunding. Okay, so due to funding cuts, 60 million over 7 years just for the Federal Circuit Court, there's been a massive shortage of judges. This has meant that it's now common for a family to have to wait 18 months to have an interim hearing. That's 2 hours, no cross-examination, and 3 years to have a final hearing, which usually takes 2 to 4 days with cross-examination. So it's hard to make these decisions, have them go through the courts when the courts are so understaffed and underfunded that it takes so long for these things to go through. A lot of parents, because of this, turn up to court multiple times only to be told that their case won't be heard and they have to come back months later, costing thousands of dollars on each side and dragging out the pain and, more importantly, the danger the kids are in even longer if it is a dangerous situation. The solution the government came up with was to merge the FCA and the FCC, so the Family Court and the Federal Circuit Court, together to form a new FCA starting in September of 2021. So obviously this hasn't started yet. It won't necessarily make sure that the cases are heard faster. It's something well worth mentioning to show that you are on top of current developments in family law, but like I said, it hasn't started yet. Property. Yay! Oh, so much more pleasant to talk about than kids. Property includes things like homes, bank accounts, companies, investments, for example, shares and superannuation. Deciding what to do with the property. This is water. It's daytime. All right, step 1. Try to reach an informal agreement about splitting up the property. The proper terminology here is property allocation. It can be sold and split, and that's the end of it. So you own a house, you sell it, you take half, I'll take the other half, easy peasy. Step 2. If the separating couple do reach an informal agreement about the allocation of the property, but they want to make it legally binding, they can apply to the family court for consent orders. The instructions are ordered by the court, but the divorcing couple agrees to it. If the way that the couple has allocated the property is fair and equitable, the court will then make it a legally binding order. Step 3. If the separating couple cannot reach an agreement, the court can order the disputing couple to attend a conference, mediation, to try to get the parties to agree. Step 4. If the mediation process is unsuccessful, the family court can make financial orders about the allocation of property. Okay, so in doing that, we need to consider the contributions by each party. So if the family court decides what will happen about the property allocation, the decision of the judge will be based on the contributions, which are both financial and non-financial, as well as the future needs of both parties. The non-financial contributions of the primary main caregiver of children, generally the woman, is usually considered to be no less valuable to the financial contributions of the income earner. If one party is seen by the judge to have contributed more, for example, their contribution was more difficult or required more skill, they can get an adjustment. So, for example, if the husband worked and the wife stayed at home, but she had mental health issues, so he had to do most of the housework anyway, then the judge might give him an adjustment of 10% of the assets, so a 60-40 split. When this happens, this is usually unfair for women, though, because the judges generally have no idea how hard it is to be a woman, let alone children, my God. Okay, in the Miranda case, the wife ended up with only a 5% adjustment, despite Mr. Miranda being a drunken, abusive gentleman who was horrible to his family, who took no role in the raising of his children and made his wife do the housework for 50 years because he thought it was women's work. So I can't really imagine how bad things need to be for a housewife to get any significant adjustment. So in this case, the split was 45-55. 45-55, 5% adjustment. Hang on, math. Oh, hang on, math. I don't know if it's going to be a 45-55 or a 52.5, and I can't math backwards, you know what I mean. Anyway, the horrible man who made her, he made her virtually be his home slave person for 50 years, and she only got a little bump. It's pretty bad for working mums as well. Judges tend not to understand how difficult it is to work full-time and then, as a woman, be expected to do the housework and raise the children as well. For example, the author of an article, "Some Husbands Are More Equal Than Wives," Law Institute Journal 2014, quote, "could not find a single judgment where it was successfully argued on behalf of a working mother that she ought to be entitled to an adjustment on the basis of at least an equal financial contribution and a superior homemaker contribution." My husband and I both work full-time. He does do some stuff around the house. I work 5 days, have 2 days off. He works 4 days, has 5 days off. But if you look at it on a week-to-week basis, he still only cooks dinner once a week. I do it the rest. So if there's ever a divorce, I'm going for a big split. Okay, what if someone doesn't comply with the court's decision? This is an issue of non-compliance, which is one of the themes, and enforceability, which is a possible criteria for judging effectiveness. Okay, so here we go. Oh, this is a good one. Super spend lands husband in jail at the age 2012. There was a gentleman who refused to follow a family court order to hand over $100,000 to his ex-wife, and he was jailed for 9 months. He instead had spent the money that the court had ordered him to pay over to his ex-wife on gambling and prostitutes. Totes worth it, 9 months jail. Binding financial agreements. Okay, turning pages. So I'm now on page 34. The Family Law Amendment Act of 2000 allowed the family court to recognise binding financial agreements. These are also known as prenups. Prenups are supposed to be binding. They can cover these areas. Okay, so it looks at financial arrangements, property arrangements, agreements on separation. Hang on, yep, but not arrangements to do with children. Okay, so you've all heard prenups in television and movies. It's an agreement made before the nuptials, pre the nuptials, as to what will happen. Usually people that have a lot of money are the ones to instigate a prenup, because in case of divorce they don't want to have to hand over half of their fortune, particularly if it's a marriage that ends quite quickly, or if there's somebody involved that some people might call it a gold digger. In 2008, since 2008, separating de facto couples can also make these agreements, and they are dealt with by the family court or federal circuit court. Oh, just like in a divorce. Okay, agreements made between married couples can actually be made at any stage of a marriage under the FLA, so it doesn't have to be a prenuptial agreement. That's the before married version. Click. Okay, you can make an agreement about finances, property, etc. during the marriage as well, and after the dissolution of the marriage. Okay, so prenup is the one that we most commonly hear about, but agreements can be made at any stage of the marriage. Okay, a binding financial agreement can be made void, invalid, if one of the partners did not get legal advice before signing, if one partner made the other sign the agreement through duress. Remember, nothing that happens under duress is legal. If one party can prove that he or she didn't fully understand the agreement. Also, if the situation of the couple has changed dramatically during the relationship. So, for example, let's say the man lost his job and couldn't find another one in 10 years, but his wife went from housewife to millionaire. The prenuptial agreement may also be ignored by a judge. Okay, there's been some controversy about lawyers getting sued for drawing up financial agreements that don't stick when they get to court. It's happened in the case of Wallace and Stelzler in 2011. Apparently, wealthy Australians who marry later in life are having to take the plunge without a prenuptial agreement. So wealthy lawyers don't want to make contracts to protect the money of wealthy people when they marry strippers when they're old. What have I written here? Lawyers back up of prenups over qualms about being sued. So essentially, prenups are not as common as television and the movies would like us to think they are. If Grandpa in his millions decides to marry a stripper and he gets a prenup drawn up, and they break up for whatever reason, and the judge goes, no, this prenup doesn't count because blah, 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 then Grandpa might try and sue his lawyers and say, you cost me $1 billion. So for this reason, lawyers are a bit wary of wanting to even draw up these types of agreements because they don't want to be held personally liable and responsible if things go wrong. Okay, this actually is the last slide for this video. Okay, so an analysis in the Law Institute Journal argued that lawyers should go on writing these agreements without worrying, because in 85% of the cases where binding financial agreements were made void by a judge, it was pretty obvious from the situation that this should have happened. The rest were because of mistakes made by the lawyers in writing them. So essentially, you can get a prenup. Most of the time when they get chucked out is because they are ridiculous, or it's quite obvious that, one party didn't necessarily completely understand what they were signing or have legal representation look over the agreement beforehand. But if you think you need a prenup, unless you are a cajillionaire, then you're marrying the wrong person. Anyway, that's that. Oh, pardon me, hiccup back. That's it for me. See you later. Bye. Oh, okay, there is more. Okay, so their use is still growing overall, but a lot of lawyers wouldn't touch them. The Ties That Bind, Law Institute Journal 2014. All right, take two. Bye.